This is a time set for oral argument in our case number CACR 18-0838, State of Arizona versus Stephen Watson. Council, we have reviewed the filings, reviewed the briefs, reviewed the records. We'd encourage you to, we've also conferenced the case. We'd encourage you to keep that in mind as you proceed with your argument. Appellant may reserve a portion of your time for rebuttal if you wish to do so. If you wish to do so, you need to keep track of your own time at the court or at the podium clock. Would ask for those who are in attendance to make sure your phones are turned off to avoid interruption of counsel and also avoid embarrassment as we proceed. With that, Mr. Carrion, you may proceed, and please, if you would, announce yourself and the party that you represent as you begin your presentation.
May it please the court. My name is Carlos Carrion. I represent the appellant, Mr. Stephen Watson. I would like to reserve 2 minutes for rebuttal. In the state's opening in this trial, they said, what the evidence is going to show is that the defendant had a plan to defraud the money from these individuals in the bank. And he did this through false pretense and misrepresentation. Essentially, he had an act that, from that act, 7 thefts were committed. So it all stemmed into one area. And as a consequence, under 13-116, it prohibits consecutive sentences when the defendant's conduct, in this case, a plan, is a single act.
Mr. Carrion, can I interrupt you for a second and
Sure.
ask, was the bank a victim in this case?
It was a victim as far as it was responsible for reimbursing the actual victims. The actual victims are the ones that were listed in counts 2 through 8, and that is the dormant accounts. I mean, it's clear to me that although the state could have been clearer in their charging document in the fraudulent scheme, they could have said to defraud the bank and or victim 1 and or victim 2 and or victim 3. It chose not to. And the state used the conversation in the sentencing to say that the bank is a victim. I agree, the bank is a victim because they must reimburse the actual victims.
But we don't have evidence in this record, do we, that they actually reimbursed? Do we have?
We do, that the bank has reimbursed, yes.
I thought there were some allegations that they had, but I'm not sure that there wasn't any testimony to that effect.
There was no testimony, and the pre-sentence report reflects that the bank had reimbursed the victims, except one of them didn't report back. So there is evidence, well, hearsay, but I think we can use the pre-sentence report that there was reimbursement. And it was left open as far as, I don't know why they chose 7 and 8, but they did. And that is a listed victim. And the bank is not listed as a victim in that case. So when Judge Pineda is talking about the victim, the bank, I think she's referring to counts 7, 8. But irrespective, they are victims for the purpose of reimbursement, and that's it. The actual victims and the state's opening statements and in their grand jury always referred to the 3 victims who had the dormant accounts.
Does it make a difference for 116 purposes that you have different victims?
Yes and no. It's how this was charged. Because, for example, in Woods, you had 2 counts of fraudulent scheme, 2 counts of theft. In each one of them, there was a named victim for the fraudulent scheme and for the theft. So in that case, where it's the same victim, it runs concurrent. In this case, we have 3 victims in 1 count. So for each
And in Woods, we're talking about there was the same scheme in that case, correct?
That's correct. So anything that falls under the scheme has to be concurrent. So in this case, it would be concurrent. But let's say we had 2 victims and the scheme only affected one of the victims, that would be run concurrent. But for the other victim, it would be consecutive. In this case, all the victims fall under the scheme, the plan. So it must run concurrent. In State v. Gordon, is where we get the test as to whether the offenses run concurrent or consecutive. And I think it's illustrious in contrast to this case. In Gordon, you had a kidnapping, sexual assault, and burglary. And the 3 prongs were identical elements. There they said, clearly the elements are satisfied, so the person's eligible for consecutive sentence. But then when they look at the facts in the case, clearly the sexual assault couldn't be committed without kidnapping. You had to restrain the individual. Also, the sexual assault couldn't be committed without the burglary by entering into the home. So in that case, the court said it can be concurrent. But then they had a 3rd prong and saying, was there additional harm? And in this case, there was no additional harm in the burglary because all that was required is entrance and no additional harm occurred. But for the kidnapping, there was additional physical acts that were not inherent with the sexual assault. So therefore it was run consecutive. And in my case, it's clear that the thefts and the fraudulent scheme all have identical elements. So it should be run concurrent. And as far as the factual prong, it's clear that you can't commit the theft without the fraudulent scheme. And again, that was the state's argument to the jury. Had Mr. Watson not violated the trust of the bank, he couldn't have accessed those accounts. Without the bank as a conduit to access the accounts, he couldn't have committed the thefts. So then it comes down to the last prong, and that is, were any additional harm committed that was beyond the actual fraud scheme?
Well, if we get to the last prong, that goes full circle back to the question of we have different victims, so there's different harm.
But the harms are all the same. That is, taking the money.
The first victim is going to disagree. The first victim is going to say, that affected me. And the second victim say, well, what affected you didn't affect me. I mean, by definition, if you have a crime crimes committed against different victims, you're talking about different harm, don't you?
Well, that's true. As far as the thefts, there are separate crimes. But for the fraudulent scheme, the actual harm is taking the money on each and every one of these thefts. I mean, there's no addition.
So it's your position the court could have sentenced Mr. Watson to consecutive terms as it relates to the theft counts, but just not consecutive to the fraudulent scheme count?
That is correct, Your Honor. In this case, the court didn't do that. But as far as the fraudulent scheme, there's no additional harm other than the withdrawal of the money. So, Your Honor, are there any other questions?
Counsel, I want you to make sure you have an opportunity to address the state's argument that probation is an imposition of a sentence. For
Well, I was going
purposes,
to wait for rebuttal, but I'll do it right now.
perhaps you can sort of whet our appetite on that. But for purposes of 116.
Your Honor, probation is a penalty, and a fine is a penalty. And I believe you wrote an opinion saying that a fine is a penalty, and therefore we have to consider double punishment. If a fine is a penalty and a punishment, then probation also can be considered a punishment or penalty. I think the problem with the word sentence is a term of art. It depends on the context in which you use it. The term of art that's usually used for is a sentence of incarceration to DOC. But in this case, the sentence refers to what penalty was imposed. And the penalty imposed was probation. And probation lessens the person's liberty. So there is punishment associated with probation. So for 7 years, his liberty is lessened compared to other citizens in the county. So as far as probation not being a sentence, I disagree. In this context, it is a sentence because he did suffer a penalty of probation.
And one final question I have, and to follow up on a question that Judge McMurray asked, where you talked about concurrent potential, your view was that concurrent sentences on the theft convictions could have been appropriate, just not on the schemes and artifices. What is the specific relief you're seeking?
The specific relief that I'm seeking is that count one be remanded to the court with instructions that count one be concurrent to the other counts.
If we agreed with you that it is a punishment that violates 116, why wouldn't, since we don't know how the court would have sentenced him for all counts had she known that, why wouldn't we just vacate all the sentences and say, here, just have a redo?
Well, for one, State v. Heller, I think we're only limited to the one count before this court, and that's count one. And there's no reason to, let's say we allow the court to resentence. She already punished him by giving him a sentence of 6 years to DOC.
Well, he hasn't served it all yet.
Well, that's
I mean,
correct.
we're slow on appeal, but we're not that slow.
Well, I didn't know that.
And he would get credit for any time he'd already spent in
That's
custody.
correct. But, I mean, all we're talking about is the court has already considered the other accounts as to what the appropriate sentence should be. The court can consider, obviously she thought he deserved a mitigated sentence. And the only reason, according to the record, that she placed him on probation is for making sure that he pays back the restitution. And as you know, as a former trial judge, you can order criminal restitution at the conclusion of the sentence. So.
Well, and I'm referring to in Viramontes where we said we couldn't, when we vacated on similar bases, we simply said, well, we don't know what the trial judge would have done had they known that they couldn't do what they did. So we just said we're remanding it all for the judge to impose a lawful sentence. And that would include all of the counts, not just the inappropriate count.
Well, I guess that'll be up to you to decide, but I would say that, you know, since the only issue that this court wanted to address was count one, it was improper and it should be concurrent. And obviously, since it's concurrent, he must serve a term in the Department of Corrections.
Mr. Smith?
Good morning, Joshua Smith, Assistant Attorney General representing the state of Arizona. May it please the court, I'm asking this court to affirm Mr. Watson's convictions because sufficient evidence supports those convictions, and to affirm the sentences imposed by the trial court. Initially, the state's position is that the sentence of probation does not, the consecutive term of probation, I should say, does not violate ARS 16 or 13-116 because 116 by its terms only applies to a sentence, and probation, as the Arizona Supreme Court stated in State v. Muldoon, is not a sentence. So because probation is not a sentence, the consecutive term of probation cannot violate 13-116.
Is probation a punishment?
It's a form of punishment, but it's distinct from a sentence. The statutes refer to it as a suspension of the sentence. That's how the cases refer to it. It's to give a defendant an opportunity to rehabilitate himself and avoid the imposition of the sentence. So while it does result in a restriction on liberty and is a form of punishment, probation in and of itself is not a sentence.
So if we're giving them the opportunity to avoid a sentence of imprisonment, then what do we do in this case if we say, oh, sure, he can serve that probation term and he violates the term and condition of probation? Can that judge then sentence him to prison? And wouldn't that be a violation of 116?
It could be, but not in this case, because even if this court wants to address it now, just for the sake of judicial economy, the consecutive term of probation is not the same act under 13-116. As you asked during defense counsel's time, the bank is a victim in this case. The parties understood the bank to be the victim for the fraudulent schemes count. The court did not impose restitution in order to allow the bank to request restitution. None of the account holders or the beneficiaries of the account holders were defrauded by Mr. Watson's conduct. Only the bank was defrauded by Mr. Watson's conduct.
Isn't that similar to an argument that could be made about an insurance company having to pay for damages as a result of an aggravated assault? We don't view the insurance company as the victim of the aggravated assault.
Well,
Right?
and with the
But the
aggravated,
insurance company gets restitution for the amounts of money they spent on the health payments that went to the victim of the ag assault.
well, two things with that. One, the statute specifically authorizes insurance companies to be reimbursed for their whatever they pay for victims for their cost. I don't know that off the top of my head, but in the aggravated assault context, the insurance company is not assaulted. In this case, the bank was defrauded because Mr. Watson, fraud was committed on the bank tellers. He went to the bank tellers and misrepresented to them that these account holders have authorized him to withdraw all the funds. So the bank was defrauded, but the account holders had their money stolen. And additionally, I believe you mentioned or asked questions about the indemnification of the victims. And I would argue that the fact that the bank could be required to indemnify the victims is a separate risk of harm that the account holders themselves are not subject to, because the bank is then, in addition to having the money taken from the accounts it controls, also required to then reimburse these account holders for Mr. Watson's criminal conduct. So I'd say that's a separate kind of harm that's distinct to the bank, in addition to them being defrauded by the Mr. Watson's conduct.
Okay, you kind of lost me there. Are the named victims the actual account holders? Are they victims?
They're the victims for the specific counts of thefts. For the fraudulent schemes, I would say that bank is the victim for the fraudulent scheme because the bank was the entity that was defrauded by Mr. Watson's conduct. The account holders were not defrauded by Mr. Watson.
Isn't this just a charging issue? I mean, the state, I'll say you, but I realize you didn't charge the case. The state could have charged this as a fraudulent scheme and a theft for every time Mr. Watson took money from a victim, right?
Conceivably, yes.
And we have case law that supports that.
Yes, I believe so, yes, Your Honor.
So, but alternatively, the state can charge it as an umbrella charge to encompass all of the different thefts, which they did in this case, right?
Yes.
Well, having elected to charge it in a particular manner, isn't the state held to that decision?
Well, even if the account holders are also the victim for the fraudulent schemes, it doesn't change the fact that the bank is also a victim for the fraudulent scheme, but is not a victim for each individual counts of theft. The complaint, the indictment specifically for each count of theft specifies which account holder is the victim for that count of theft. So I believe counts 2 through 4 are the estate of the Galvesini estate, the counts 5 through 7 or the Kelly counts, and count 8 is the account belonging to Ms. Samuels. The bank is not the victim for any of the individual theft counts. And going in,
Let's assume for the sake of argument that we agree with you that we have multiple victims and one of being the bank. Is there additional harm here? The bank has the same harm as all of the victims, the loss of that money, and no additional harm than that.
well, as I said, the bank was defrauded in that the additional harm is only one of the 3 prongs from Gordon. The second prong is.
But don't you have to meet all 3 of them to get consecutive sentences?
A lot of the analysis from cases addressing Gordon is somewhat perfunctory. I don't believe you have to meet all 3 of them. Roseberry seems to suggest that the third prong is unnecessary if the second prong is met. And under the second prong, it looks to whether whether the ultimate crime can be committed even if you subtract out the lesser crimes. And in this case, if you remove any one of the individual thefts, you can still convict Mr. Watson of the fraudulent scheme. So this is distinct from Woods. In Woods, he had 2 counts of fraudulent schemes and 2 counts of theft, but each fraudulent scheme was premised on a single count of theft. And the theory of theft was that he obtained the disability benefits that he was not entitled to. So without the theft, there is no fraudulent scheme in Woods. Here, without the theft of, say, the Galvesini accounts, you still have the thefts of the other accounts, and therefore you still have the fraudulent schemes.
But that goes back to my question, that's a charging issue, isn't it? I mean, it works because that's the way it was charged in Woods, but that's not how it was charged here. The jurors could have acquitted Mr. Watson of any one of the thefts, and we'd still have the same issue that's being presented, is whether or not because of the way it was charged, it's one that encompasses each individual act.
Well, 2 things with that. First, the fact that the jury could have acquitted on any of the counts of theft and we'd still be here with the fraudulent schemes would indicate that the thefts are separate and distinct acts from the fraudulent schemes, and because they're separate and distinct acts, consecutive sentences are appropriate under 13-116. Mr. Carrion, in his comments, suggested that the fraudulent schemes is the overall plan, and I would liken that to a criminal conspiracy where you can have a single count of conspiracy that encompasses multiple substantive crimes, but you can still have the consecutive sentences because the plan is a separate act from the actions done to complete that plan. So here, even
okay,
if...
hold on. Let's take it one step at a time. Because with conspiracy, you don't have a general crime of conspiracy. You have a crime of conspiracy to commit another predicate crime. And so in that hypothetical that you just said, it would be conspiracy to commit, and then you take the highest offense that he was convicted of. So it would be conspiracy to commit whatever. And then you'd have individual charges that would be outside of that.
Well, Roseberry dealt with conspiracy to transport marijuana for sale and the substantive charge of transporting marijuana for sale, and those were the only 2 drug counts, and those are the only 2 counts that were subject to the 13-116 analysis. And in there, it concluded that the conspiracy can be charged or sentenced consecutively to the actual substantive offense. So I would liken the overarching plan of the fraudulent schemes to an overarching conspiracy to commit these thefts, and even if you take away any one of these individual thefts, you still have the overarching plan for the fraudulent schemes. And because you can commit the fraudulent schemes without any one of these individual specific thefts, the second prong of the Gordon analysis is met, which would indicate that consecutive sentencing here is appropriate.
Let me ask counsel, you have likened to conspiracy offenses, but as Judge McMurray points out, those are somewhat different here, and that wasn't charged this way, right? And Judge McMurray has asked, or has pointed out another way it could have been charged. Do we have any sort of information in the record as to why these charges were alleged in this specific manner in this given case?
I didn't see anything in the record that would suggest why the indictment was charged in this specific way. I can imagine that it may have been a matter of, it simplifies the presentation to the jury in kind of a narrative way to let the jury know this is the overarching plan and then prove each of the individual thefts. So I think it may have just been a manner of making it the presentation easier. But I don't have anything from the record or any conversation with whichever prosecutor charged the case to suggest why it was charged in this particular way.
Didn't they allege the allegation that there was an aggregate amount that they would only get if they filed it the way they did here? There was a $100,000 aggregate. The jurors didn't come back on that basis for whatever reason.
I don't remember that part from my review of the record, Judge, about the aggregate amount. I assume the jury came back on misdemeanors for the Gobblesini account because Mr. Watson testified that he reimbursed Mrs. Gobblesini the money he took from the accounts. That would be my guess for why some of the amounts were lesser. But again, there's nothing from the record that would say that that's definitively the reason why the convictions were the way they were. I guess just to complete the Gorin analysis under the first prong, the state's view of the fraudulent schemes is that it was unnecessary to establish what Mr. Watson did with the money once he obtained it for the fraudulent scheme. Or in other words, the fraudulent scheme was complete once Mr. Watson received the cashier's checks, and that the evidence for what he did with the cashier's checks after that is the evidence sufficient for the theft counts, and as a result, the facts necessary to convict Mr. Watson of the fraudulent scheme were distinct from the facts necessary to convict him of the thefts, and therefore the first prong of Gordon is also met. But I do want to move on to discuss if this court were to find that the consecutive term of probation did violate 13-116, what the remedy should be. Mr. Carrion suggested that only the remand of the probation term should be done. I would agree with Judge McMurdy that by reversing the probation term, we don't know what the trial judge would do, and as a result, every count should be resentenced. The trial judge expressed that she was placing Mr. Watson on probation because she thought he was an excellent candidate for rehabilitation, and also to make sure that there's a way to make sure he's paying his restitution. And if that were no longer available, we can't say that the judge would have still made everything concurrent and he would only be given a total of a 6-year prison term. So if this court were inclined to find that the consecutive term violates 13-116 such that new sentencing is required, that this court remand for resentencing on all the counts rather than simply the fraudulent scheme count. And unless the court has any questions about the sufficiency of the evidence issue that was raised in the opening brief and the answering brief, I would just rest on the briefs on that case. And if there are no other questions, I'd ask this court to affirm the convictions and sentences of the trial court. Thank you very much.
Thank you. Mr. Carrion, rebuttal.
Your Honor, I had a hard time hearing him, but as far as, sorry, I'm going to take this off. Excuse me, 1 second. I'm all right. The part I'd like to address is the state's theory about when the thefts were completed versus the completion of the fraudulent scheme. It's clear that when my client received the money in whatever form it was, both the theft and the fraudulent scheme were completed. There's no, in all the fraud scheme cases I've seen, I've never seen it parceled out to when a check is made. For example, Woods deals with benefits. It wasn't parceled out. It was, he received the benefit, the theft was also committed in addition to the fraudulent scheme. So in this case, as far as the second prong, it's been met. There's no, the timeline is a bit of fiction. In all the thefts, my client received the money. The fraudulent scheme was to receive the money. So once he received the money, both acts were completed. Any other questions?
No, Counsel.
Thank you for your time.
Thank you very much. Counsel, we appreciate your briefing. We appreciate your oral presentation here today. We'll take the matter under advisement. We'll issue a written ruling in due course. We'll stand in recess while the courtroom set up for our next oral argument. Thank you.